Mr. Patterson.
Mr. Chief Justice, and may it please the Court, this case turns on decisions made by Congress in the Gun Control Act of 1968. First, Congress altered the common understanding of firearm to include other weapons that may readily be converted to firearms. Second, in a departure from prior federal law, Congress decided to regulate only a single part of a firearm, the frame or receiver, and Congress did not alter the common understanding of a frame or receiver. ATF has now exceeded its authority by operating outside of the bounds set by Congress. One, ATF has expanded the definition of frame or receiver to include items that may readily be converted to a frame or receiver. And two, ATF has expanded the definition of firearm to include collections of parts that are not weapons and that do not include a frame or receiver. Some concern has been raised about circumvention, but of course complying with a statute is not circumventing it. And as this Court said in Abramski, which has already been referenced, Congress in the Gun Control Act did not seek to pursue its purposes of controlling access to firearms to the nth degree. And notably, Congress did not regulate the secondary market for firearms. And that secondary market is a much bigger source of firearms for criminals than privately made firearms. There also has been questions raised about the agency's prior practice. There definitely has been a sea change by the agency here. The agency projected that its rule would put 42 out of 43 unlicensed manufacturers out of business. And what the agency said in the Syracuse litigation was they said an unfinished frame or receiver does not meet the statutory definition of firearm simply because it can be designed to or can readily be converted into a frame or receiver. That's the exact standard they've now adopted. Instead, what they looked at was whether critical machining operations had taken place. And to be clear, we have no quarrel with that prior practice. We have raised as alternatives, one, something has to be completely machined, or two, the critical machining operation test. And the latter we submit is more consistent with the statutory language and solves the machine gun problem. Because if you say in the machine gun provision, a frame or receiver is also regulated, and if one hole is all that separates a semi-automatic receiver from a machine gun receiver, it's hard to see how the readily standard would not also be applied there. I welcome the Court's questions.